Good morning again, everybody. This is the second portion of the lecture. It's probably going to be longer than the first part was regarding partnerships, another potential form of doing business if you need to form a business organization. This is a chapter outline. Once again, as always, I urge all of you to read the chapter. These are the learning objectives. What are the three essential elements of a partnership? What are the fiduciary duties of partners in a general partnership? What is dissociation? What happens when a partner dissociates from a partnership? What advantages do limited liability partnerships offer to business persons that are not offered by general partnerships? What are the key differences between the rights and liabilities of general partners and those of limited partners? All right, partnerships, definition and status. A partnership is an association of two or more persons to carry on as co-owners a business for profit. This relationship is similar to an agency relationship. The Uniform Partnership Act, UPA, governs the operation of partnerships in the absence of an express agreement, but the partners are free to establish rules for their partnership that differ from those stated in the UPA. Courts often look to the following to determine whether a partnership exists: sharing of profits and losses, joint ownership of the business, and equal right in the management of the business. A partnership is treated as an aggregate of the individual partners, which means that a partnership usually can sue or be sued, collect judgments, own real property, and have all accounting procedures performed in the name of the partnership entity. As stated, sharing of profits and losses from a business creates presumption that a partnership exists, but courts will not presume that a partnership exists if the shared profits are received as a debt by installments or interest on a loan, wages of an employee or payment for the services of an independent contractor, rent to a landlord, an annuity to a surviving spouse or representative of a deceased partner, or sale of the goodwill of a business or property. And while a partnership has, in effect, joint ownership of property, it's the parties' intentions that are the key. Joint ownership of property does not in and of itself create a partnership. And there are many kinds of joint ventures where there's joint ownership that is involved that are not considered to be partnerships. Likewise, equal management rights. In general, each partner has a single vote in the management decisions, regardless of his or her proportional interest in the business, unless the partners have agreed otherwise. So you can have a 90% partner who has two 5% partners, and the two 5% partners, in the absence of another agreement, can make the management decisions by a vote of 2-1. So there are two potential ways to look at a partnership. One is as an entity, and that's the modern view, versus the aggregate theory of partnerships. So a majority of the states treat a partnership as an entity for most purposes. It can usually sue or be sued, collect judgments, have all accounting procedures performed in the name of the entity. A minority of states look at the aggregate theory of partnerships and simply treat the partnership as being a joint entity comprised of the partners. Tax treatment of partnerships. Partnership is a pass-through entity. It In and of itself, it has no tax liability. It does file an information return, tax return that's submitted by the partnership that only reports the business's income and losses. The partnership itself does not pay taxes, but each partner's share of profits and of certain individual items that get passed through are passed along to the partner, who then reports those items on their own individual tax return. And for more on tax treatment of partnerships, make sure that you take Tax 2 if it ever gets offered again. Partnership formation. Articles of partnership. A written agreement that sets forth the rights and obligations of each partner with respect to the partnership. Partnership agreements can also be oral or implied by conduct. Partnership agreement may specify the duration of the partnership in terms of a date or the completion of some undertaking. A partnership whose terms is so limited is a partnership for a term. Any dissolution of the partnership prior to the term without the consent of all of the partners will leave the partner or partners responsible for the dissolution personally liable for any resulting losses. A partnership agreement that is silent as to duration implies a partnership at will. Any partner may dissolve the partnership at any time without incurring liability. Partnership by estoppel. A partnership imposed by a court when non-partners have held themselves out to be partners or have allowed themselves to be held out as partners, and others have detrimentally relied on their misrepresentations. You will recall that this is a familiar concept throughout contract law. Okay, here we have another handy exhibit showing you common terms that might be included in a partnership agreement. Probably everything here should in fact be addressed in a partnership agreement. First of all, we have the basic structure. It makes sense to have the name of the partnership, name of the partners, the location of the business, and the state law under which the partnership is organized, the purpose and duration of the partnership. Second is capital contribution, the amount of capital that each partner is contributing, the agreed on value of any real or personal property that is contributed instead of cash, how the losses and gains on contributed capital will be allocated, and whether contributions will earn interest. Third, sharing of profits and losses, percentage of the profits and losses of the business that each partner will realize, and what distributions of profit will be made and how net profit will be calculated. It's important to remember here that the tax attributes of partnership can also be distributed without regard to the overall percentage of either capital contribution or profit percentage. So it's possible, for example, to have one partner receiving even all of the tax attributes that are favorable, such as depreciation, while another partner receives things that are not necessarily favorable, such as the profits. Management and control can be divided among the partners in any manner they see fit, as can their voting rights. Dissociation and dissolution, whether or not dissociation of a partner will dissolve the firm. In the absence of any other agreement, typically in a general partnership, any dissociation does terminate the partnership. It doesn't have to be that way, though, not if you agree otherwise. How a partnership property will be valued and apportioned on dissociation and dissolution, and whether an arbitrator will determine the value of that property All of these are things that ought to be considered in a partnership agreement. So in the case of a partnership by estoppel, the court is imposing this partnership, is treating the persons who had been either held out to be by themselves or held out by others to be partners as though they were in fact partners. Okay, rights of partners, management rights. Unless it's otherwise agreed, all partners have equal management rights. Each partner has an equal vote, regardless of the relative size of his or her capital contribution, and partnership decisions require a majority vote of the partners, except in the following cases, which require unanimous consent: altering the essential nature of the partnership's business or entering a wholly new business, admitting new partners or altering the capital structure of the partnership, or amending the partnership agreement. Interest in the partnership. Each partner is entitled to or obliged to bear the share of the partnership's profits earned or losses incurred set forth in the partnership agreement, or an equal share if the agreement is silent. Compensation. Unless otherwise agreed, partners do not receive a salary for any work they do for the partnership's benefit. Rather, they're paid a share of the partnership's profits, plus a return of their initially invested capital when the partnership terminates. Inspection of books. All partners must have access to partnership books and records. Each partner has the right to receive and a duty to produce full and complete information concerning all aspects of partnership business. Accounting. An accounting of partnership assets or profits is required to determine the value of each partner's share in the partnership. An accounting can be performed voluntarily or it can be compelled by court order. Property rights. Partnership property, which is the property acquired by a partnership, such as property that was originally contributed to the partnership, and anything later purchased by the partnership or in the partnership's name, is the property of the partnership and not of the partners individually. A partner is not a co-owner of partnership property and has no right to sell, mortgage, or transfer it. Because partnership property is owned by the partnership as an entity and not by the individual partners, the property cannot be used to satisfy the personal debts of individual partners. A partner's creditor, however, can petition a court for a charging order to attach the partner's interest in the partnership, his or her proportionate share of any profits that are distributed, to satisfy the partner's obligation. Partners' fiduciary duties. Under the UPA, a partner's duty of care involves refraining from grossly negligent or reckless conduct, intentional misconduct, or a knowing violation of law. The duty of loyalty requires a partner to account to the partnership for any property, profit, or benefit derived by the partner from the partnership's business or the use of its property. A partner must also refrain from competing with the partnership in business or dealing with the firm as an adverse party. In fulfilling her or his duties, each partner must act consistently with the obligation of good faith and fair dealing. In other words, a partner's fiduciary duties may not be waived or eliminated. A partner may pursue his or her own interests without automatically violating these duties as long as the partner discloses the interests to the other partners. Each partner is an agent of the partnership and of each other partner. Therefore, agency concepts of actual and apparent authority and ratification apply to acts of a partner. A partner may expose the partnership to tort liability. A partnership may limit the capacity of a partner to act as the firm's agent or transfer property on its behalf by filing a statement of partnership authority in a designated state office. The extent of implied authority is generally broader for partners than for ordinary agents. Partners' liability. One significant disadvantage associated with a traditional partnership is that the partners are personally liable for the debts of the partnership. Joint liability. In partnership law, the partners shared liability for partnership obligations and debts. A third party must sue all of the partners as a group, but each partner can be held liable for the full amount. Joint and several liability. In partnership law, a doctrine under which a plaintiff may sue and collect the judgment from all of the partners together, jointly, or one or more of the partners separately, severally, or individually. A partner can be held liable even if she or he did not participate in, ratify, or even know about the conduct that gave rise to the lawsuit. Newly admitted partners are liable for debts and obligations incurred before they join the partnership only to the extent of their capital contribution. Dissociation, the severance of the relationship between a partner and a partnership. A partner may cease to be associated with the partnership's business by notifying partners that he or she wishes to withdraw due to an event specified in the partnership agreement, by unanimous vote of the other partners under one or more of the circumstances that are set forth in the UPA, by the order of a court or an arbitrator, or due to death, incapacity, bankruptcy, or assigning a partnership interest for the benefit of creditors. A partner always has the power to dissociate from the firm, but he or she may not have the right to do so. If a partner lacks the right to dissociate, for example, it's a breach of the partnership agreement, then the dissociation is considered wrongful under the law. Upon a partner's dissociation, his or her right to participate in the management and conduct of the partnership business terminates. The partner's duty of loyalty ends, and the partner's duty of care continues only with respect to events that occurred before dissociation. After a party's dissociation, the partnership must purchase his or her partnership interest. The buyout price, amount payable to a partner on his or her dissociation from a partnership, based on the amount distributable to that partner if the partnership had been wound up on that date and offset by any damages for wrongful dissociation. For 2 years after a partner dissociates from a continuing partnership, the partnership may be bound by the acts of the dissociated partner based on apparent authority. To avoid this possible liability, a partnership should notify its creditors, customers, and clients of a partner's dissociation. Either the partnership or the dissociated partner can file a statement of dissociation in the appropriate state office to limit the dissociated partner's authority to 90 days after the filing. Partnership termination. Dissolution, the formal disbanding of a partnership or a corporation. Partnerships can be dissolved by acts of the partners, by operation of law, or by judicial decree. For example, any partnership can be dissolved by the partners' agreement. The partnership agreement may state that a partnership will dissolve upon a certain event, such as a partner's death or bankruptcy, or at the end of a fixed term. Any event that makes it unlawful for a partnership to continue its business will result in dissolution. Winding up. The second of two stages in the termination of a partnership or corporation in which the firm's assets are collected, liquidated, and distributed, and the liabilities are discharged. A partnership's assets are distributed according to the following priorities: payment of debts, including those owed to partner and non-partner creditors, return of capital contributions, and distribution of profits to partners. Before entering into a partnership, partners may agree that one or more of the partners will buy out the other or others in the event that the partnership dissolves, known as a buy-sell agreement or a buyout agreement. Limited liability partnerships, or LLPs. This is a hybrid form of business organization that is used mainly by professionals who normally do business in a partnership. An LLP is a pass-through entity for tax purposes, but a partner's personal liability for the malpractice of other partners is limited. To form an LLP, the appropriate form must be filed with a central state agency, usually the Secretary of State's office. And in Florida, yes, it is the Secretary of State's office. And the business's name must include either limited liability partnership or LLP. When an LLP formed in one state wishes to do business in another state, it may be required to register in the second state. An LLP allows professionals, such as attorneys and accountants, to avoid personal liability for the malpractice of the other partners. A partner in an LLP is still liable for his or her own wrongful acts, such as negligence. And when more than one partner in an LLP is negligent, some states provide for proportionate liability. That is, for separate determination of the negligence of the partners. Others, however, would stick to the traditional concept of joint and several liability. Limited partnerships, or LPs. These consist of one or more general partners and one or more limited partners. So, limited partnership consists of the general partner who assumes responsibility for the management of the partnership and has full liability for all partnership debts. And a limited partner is somebody who contributes capital to the partnership but has no right to participate in its management and has no liability for partnership debts beyond the amount of the initial investment, or, well, subsequent investments that might be made as well. The formation of a limited partnership is a public and formal proceeding that requires the partners to sign a certificate of limited partnership, a document that must be filed with a designated state official to form a limited partnership. General partners are generally liable to the partnership's creditors. Thus, at least one general partner is necessary in a limited partnership so that someone has personal liability. The liability of a limited partner is limited to the capital that she or he contributes or agrees to contribute, as long as the limited partner does not participate in management. In most places, a corporation can be a general partner, in which case there isn't really the kind of exposure to an individual that a general partnership would have created. Finally, we're going to talk about dissociation and dissolution of limited partnerships. General partner has the power because they have all of the management power to voluntarily dissociate or withdraw from a limited partnership, unless the partnership agreement specifies otherwise. Limited partner can withdraw from the partnership by giving 6 months' notice, unless the partnership agreement specifies a term, which most do. An LP can also be dissolved by court decree. On dissolution, creditors' claims, including those of partners who are creditors, take first priority. After that, partners and former partners receive unpaid distributions of partnership assets and, except as otherwise agreed, amounts representing returns on their capital, contributions, and proportionate distributions of profits. All right, this concludes the second portion of the lecture portion of today's lesson. Please look for the quiz material that will come under separate email cover.